Test 1, 2, 3, 4. Test. Testing. Test. Test.
Test. Test, test. Testing 1, 2, 3, 4. Test.
You're all set, Rick? Okay. It's 9 o'clock. We're going to call to order the November 8th, 2017 Legislative Committee meeting of the Contractor State License Board. Good morning. I'm Augie Beltran, the committee chair. Only board members who are members of the committee may sit at the table. Other board members who are in attendance must observe from the audience. If a quorum of the board is present, those members who are observing cannot participate in the discussion. We have excused absences for members Michael Layton and David Delatorre. Roll call, please, Mike.
Augie Beltran.
Present.
Linda Clifford.
Present.
Susan Granzella.
Present.
Joan Hancock.
Present.
Do we have a quorum?
We have a quorum.
Thank you. Next, I'd like to invite everyone around the table to introduce themselves, and staff and committee will also allow people in the audience to introduce themselves. Let's start out with Counselor Kurt.
Thank you, Mr. Chairman. Good morning, everyone. Kurt Hepler, Supervising Attorney, Department of Consumer Affairs.
Tanya Corcoran, Chief Deputy Registrar, Contractors Board.
David Fote, Registrar.
Joan Hancock, Board Member.
Michael Janetsky, Legislation Chief.
Augie Beltran, Board Member.
Susan Granzella, Board Member.
Laura Zuniga, Chief of Licensing.
Betsy Figuera, Manager, Legislative Division.
Rick Lopes, Chief of Public Affairs.
Ma'am?
CSLB, Amy Cox-O'Farrell.
CSLB, Greg Diamonds. Ed Lang, Board Member.
Richard Marcus, Pacific Advocacy.
Stacy Paul, CSLB Budgets.
Debbie Stephan, CSLB. Natalie Waltmore, CSLB.
Rick Pierce, Basic Crafts.
Thank you. Next on the agenda is staff recognition. We'd like to recognize a member of our information technology team, Greg Dines. Greg is the lead technician and system software specialist 3 here in Sacramento. He joined CSLB as an account clerk in 1985 with the CSLB cashiering service. Since 1993, Greg has worked in the CSLB Information Technology Unit, specializing in networks, and was a supervisor in the IT division for many years before assuming his current role. Please join us in acknowledging Mr. Dines with his certificate of appreciation for his 32-plus years of dedicated and exemplary service to CSLB. Come on up. Greg, thank you for your service.
Thank you.
This certificate of appreciation is awarded to you for your exemplary service, dedication, and commitment to the Contractor State License Board in supporting the information technology functions of the board. Your commitment to the CSLB over the many years is outstanding. You continue to provide service morning, noon, and night. Thank you for that. I'll be calling you about 9 o'clock tonight. You keep CSLB IT systems and technologies current, which is critical in this time of ransomware, hacking, and viruses. The CSLB thanks you for your many years of exemplary service. Thank you so much. Would you like to say something? Feel free to.
Oh, no, it's just been great working here. This has been a family. Known David for, 26, 27 years, and chances to leave during the years, but CSLB is a home and a good place to work with great people, so I've been honored to be here.
Thank you.
So thank you.
Thank you for your service.
You're standing in front of Old Glory over here.
Okay, thank you.
Okay, now we move on to public comment. This item is provided for public comment pertaining to items on the agenda as well as items not on the agenda. However, the committee cannot discuss or take action on any items not listed on the agenda. The CSLB welcomes public comment on any item on the agenda, and it is the CSLB's intent to ask for public comment prior to the committee taking action on any agenda item. But if for some reason we forget to ask for public comment on the agenda item, a member of the public desiring comment on the item should raise their hand and they will be recognized. Also, to allow this committee sufficient time to conduct its scheduled business, we will be limiting public comment to 5 minutes per individual. Is there any individuals that wish to address the committee at this time? Are there any comments from the committee at this time? Okay, wonderful. Mike, it looks like we're on update of 2017 legislation. That would be in our packets on page 9. You've got the chair, my friend.
Good morning. I would just say there is a handout number 1 on the table out there that has a chart that's updated from the committee packet. So we are just going to review the final disposition of the following 7 bills, all of which the governor has signed since our September board meeting. AB 1070, Gonzalez-Fletcher, regarding solar systems contracts disclosures. This bill requires additional information be provided to consumers before contracts for solar energy systems are entered into. The CSLB Enforcement Division will work with the Public Utilities Commission to develop and make available a solar system disclosure contract, and by January 1st, 2019, begin tracking certain information about solar complaints. AB 1278, Contractor Licensing Final Judgments. This bill affects the time period for entry of final judgment against a contractor's license record. The impact is minor and absorbable for CSLB and requires adjustments to the licensing computer systems that currently track judgments and personnel. AB 1284, California Financing Law, Property Assessed Clean Energy Program, Program Administrators, and of course that refers to PACE. Through the California Finance Lenders Law, this bill institutes a licensing system for PACE program administrators who will ensure that PACE solicitors meet certain requirements before they may enter into an assessment contract with a property owner. Last week, CSLB met with representatives from the Department of Business Oversight to discuss implementation of this bill, which requires the Department of Business Oversight to implement the licensing system by January 1st, 2019. AB 1357, Home Inspectors, Roofing Contractors, Roof Inspections. This bill does not directly impact CSLB, as CSLB does not enforce or administrate the provisions of the law related to home inspections. It could possibly increase the number of complaints CSLB would need to investigate if it results in more licensees performing repairs as a result of roof inspections. SB 242, another property assessed clean energy program dealing with program administrators. This bill provides new requirements and conditions for PACE third-party administrators about oral representations that are made to homeowners regarding the installation of renewable energy sources in small residential structures. This bill does not directly impact CSLB. SB 486, Contractor State License Board Letter of Admonishment. This bill authorizes the CSLB to Registrar to issue a letter of admonishment in lieu of a citation in appropriate circumstances, and authorizes CSLB to conduct informal conferences to resolve them. The Enforcement Division is in the process of drafting the language of the letter and identifying the staff who will administer the conferences statewide. SB 800 was an omnibus bill making technical, non-substantive changes to the contractor state license law. There's some clarity provisions. We're eliminating a confusing provision regarding the reassignment of a contractor's license in the case of an asset sale, and it does clarify certain language regarding individual taxpayer ID numbers and federal employer tax ID numbers. In addition, on October 7th, the governor did veto AB 1190 regarding the Department of Consumer Affairs BREEZE system relating to the licensing and enforcement tracking computer systems used by DCA. That concludes the legislative update for the bills that CSLB was tracking this year. Are there any comments from the committee? Is there any public comment?
Question?
Yes, go ahead.
I'm just wondering if there's any notes that you read off that might be significant for us to have. Would you mind sending them forward if it's, subsequent to the governor's signature or veto?
Most certainly, and I will also be developing a tracking chart with action items for CSLB for the implementation of these various bills as they come forward. And I'll share that with you as well.
Is there any additional comment from the board? Anything else from the public?
Mr. Chairman, just as I understand it, the committee members were provided a letter from Mr. Jeremy Hutton of Renew, I'm sorry, I can barely get my toaster to work, Renew Financial. And so he asked, I think, as I understand it, that the missive, and there's a public copy there on the table, that this missive be read into the record. So if there's no objection, we'll just consider this matter read in the record if all members have been provided a copy.
Any objection from the board? Any question from the public? Thank you. We move on to discussion item E. Go ahead. Oh. You just go ahead and run with it.
Sure. So this is item E, the review, discussion, and possible action on proposed 2018 legislative proposals. There are 4 legislative proposals for possible 2018 bills that staff present for recommendation as follows. The first one is to remove statutory authority for the registrar to accept cash deposit in lieu of bond. This would add section 7071.4 to the Business and Professions Code, and it would amend Business and Professions Code section 7071.17, 7074, 7091, and would repeal section 7071.12. There is a handout, it's handout number 2 in the back on the table, which does have some revised proposed language that will go in place of the proposed language for this proposal that's in the packet. The existing language in the contractor state license law allows a licensed contractor to file a cash deposit with a bank or a savings association in lieu of a bond and meet the CSLB bond requirements. The issue we have here is that bonds, as you know, are for consumers who are damaged by violations of the contractors law. And if a bond is held with a surety company, a consumer can make a relatively straightforward good faith claim to obtain the bond. What we have here with the cash deposits, the civil code allows alternatives in lieu of these surety bonds. The issue with that is we are unable to, we don't have jurisdiction over the funds that the licensees deposit with banking and savings associations. So what happens is they file the bond, and then when a claim is made against it, the civil code not only requires the consumer to sue the registrar in name and start a civil action, but and join the CSLB, it requires the consumer to go to court, which is not fair. Currently, there's only 514 licensees with cash deposits of all types. It's more than just a contractor bond. There's employee worker bonds, there's LLC bonds, there's qualifier bonds, and we are aware of 6 cases in which the money is simply gone when the consumer tries to obtain against the bond. Requiring the lawsuits really jeopardizes consumers. This proposal is really modified after another board, at least one DCA board, has eliminated a cash deposit program. So what this proposal will do is eliminate the ability for licensees to file cash deposits. We believe it exists, well, there's 2 reasons it exists. It exists to make civil litigation easier, which doesn't affect us. But what does affect us is CSLB licensees with bad credit or low credit can rather than pay the amount to get a surety bond, they can file the cash. Well, we don't have any evidence that shows that a contractor can't obtain a bond regardless of credit for between $100 and $700 a year. We think that this would just really eliminate so many headaches for consumers and CSLB. Thank you.
Thank you, Michael. I'm going to read the staff recommendation, and then I'll take questions. And the recommendation is that we move this to the full board, removing the authority of the registrar to accept a cash deposit in lieu of a contractor's bond. The recommendation includes a request that the committee delegate to the registrar the authority to make minor and technical changes to the proposal as necessary. Are there any questions from the board on this?
Yes.
Go ahead.
So I'm definitely in favor of us getting rid of taking cash deposits. I mean, we really don't have the facility to do it in, that is a protection for the consumers. And however, I'm trying to figure out, because of the way you provided handout 2, what the change, so I know what's in the book, right? Is the only change that's in handout 2 the addition of paragraph 71.4?
Excellent question. That's absolutely right. The only change in the handout in the back is the addition of an entirely separate statute. So what we did in the committee packet was we included the abrogation language in the existing statute. We scrapped that idea and we took a statute from the Structural Pest Control Board, who's already done this, and modeled it for our own purposes, and that's the addition on the handout in the top.
So here's what I'd like to ask in the
Sure.
future, especially if we're going to get these, kind of like the night before, is that you identify the changes so that we, and it doesn't have to necessarily be highlighted, maybe that's too much for color, and but although we are already printing in color, so maybe it's not a problem. It would be really helpful if when we got anything outside the book, as, as something like, we've now moved to this step.
Sure.
Could you just highlight it or something for us? So that-
Absolutely.
Yeah, because I spent, quite a bit of time trying to figure out if there was any other, and the lined out isn't that easy to read
Sure.
anyway, so.
Sure.
And I couldn't figure out whether it was actually repealed or if we're trying to repeal it, so anyway. enough said,
Absolutely.
but-
I'll make that more clear in the future. And just a quick point of clarification, the struck out provision in the handout and in the book of 707112, it does repeal the entire section that authorizes the cash deposit. And then the remaining language are existing statutes, and you'll see there's minor strike-throughs
Right.
throughout. And that was just our way of removing the cash deposit reference in the remaining statutes.
Okay. And I have one other question.
Sure.
We've often said, if there needs to be a minor change, go ahead and make it, right? So I'm just interested in, Kurt, maybe you can address this. How do we define that minor thing? Because for me, if it changes any of the meaning or the methodology, it feels like maybe it should come back. Whereas if you just forgot to strike out one place where it said cash deposit and the intention was to get it everywhere, I would obviously never have a problem with that.
Excellent question, Ms. Clifford. I think it's, generally speaking, you would delegate to make minor, non-substantive comments, something grammatical, some syntax issue, we forgot a word like of or a. But if it's anything substantive that would change the intent, then I think you would either want it to come back here or the board would consider it fully at the next stop, either way. So anything other than a omitted word, some typography, some syntax error, something like that, I think the committee may want to consider looking at it again.
Okay, I appreciate that, especially if it's like a methodology or a expansion of anything. That's my only, yeah.
May versus shall. The most famous two words.
Chair,
Right.
Chair, question?
Yes.
So are we not considering this significant or substantive? This repeal, it says it's repealed,
Right.
and I don't have it in my contractor's license law book as having been repealed.
No, I think the question, Ms. Hancock, was Ms. Clifford's question about what kind of authority were you delegating to the registrar if it was a significant or substantive change? This legislative proposal clearly is a substantive change from existing law, because obviously you take cash deposits or things in lieu of a bond, and if this passes, CSLB won't be permitted anymore.
And so having said that, the addition of 71.4 would be considered significant or substantive as well? And if so, I guess all I'm getting to is, in fairness to the public, to get this information the night before, shouldn't the public be given a 10-day notice to review this information prior to if we're about to vote on it? I don't know that I feel comfortable with that unless you want to go into some greater detail about,
Certainly, Ms. Hancock, I'm sorry to interrupt. I think what has happened is I think conceptually, Mr. Jametsky, if you would agree, I think even in the notebook, I'm saying even in the handbook or handout and even on the notice, I think the thought was that CSLB was no longer going to accept cash deposits. your regular council, I'm filling in for, we had a meeting, I think Monday, just trying to iron out some details. Part of this is my fault because I came at it from a different angle, my experience with structural pest when they eliminated it for the same essential reasons you did. So I don't believe the message of we're not taking anything but a bond anymore has changed. I believe the public was given adequate notice that just the mechanism of how you're not going to accept it has changed slightly. Would you agree, Mr. Jemnetsky?
100%. The core of the gravamen of the proposal hasn't changed since the committee packet was published. All that was changed was we removed the one sentence from the proposed language and made it its own statute, and that's what the committee was provided last night.
And that's 7071.4.
Correct.
Yeah, and additionally, we're moving this to the big board, so the public will have, when's the next big board meeting, David? January, February?
December, yes.
So they'll have till,
December
yeah, they'll have till December to disseminate this information as well.
So all the information in 7071.4 is in the body of the statute already? Because there is no 7071.4
Correct. This is just a proposal for the committee to consider.
adding it.
Correct. And that would also consider the,
And is the language in it consistent with the language in 7071?
it is. And the reason it's a
That's
standalone.
all I needed to know.
Sure.
Okay, thanks.
Any other questions from the board? Anything from the public? Chair would accept the motion to follow staff recommendation.
So moved.
There is a motion on the floor. Is there a second?
Second.
There's a motion and a second. Clifford Granzella. You need to note that.
Yes, we'll call the vote. A motion is required.
So there's a motion, and so the motion was Clifford. The second was Granzella. And now please call a roll call vote.
Augie Beltran.
Aye.
Linda Clifford.
Aye.
Susan Granzella.
Aye.
Joan Hancock.
Aye.
Motion carries. We move on to item number 2, multiple firm license qualifier requirements.
This proposal is a proposed amendment to Business and Professions Code Sections 7068.1, 7071.9, 7071.10. The issue here is that there are consumer protection concerns when a licensed qualifier is not actively involved in the business and/or is acting as a qualifier on multiple contractors' licenses. A person cannot act as a qualifier for more than one individual or firm unless meeting certain exceptions in statute. One of the exceptions allows the person to show at least 20% common business equity among the licenses for which they qualify. And an additional equity provision, qualifiers are also required to have a bond of qualifying individual unless they meet certain exceptions. And one of those exceptions allows a person to avoid the qualifier bond by showing 10% or more business equity in the company. The issue we have here, there's two issues. There's a cottage industry that is developed in the private sector, these third-party matching services that place qualifiers with personnel onto licensees, and to directly avoid the direction and control provisions of 7068.1, a qualifier must have direction and control of construction operations. This has been an issue for a long time. In 2013, CSLB sponsored a bill that made a violation of this section a misdemeanor. Those are hard cases to prove. They must go to the DA, and we're still seeing the issue with these third-party matchmaking services. In fact, just the other day in the SF Gate, there was an article of an attorney who's being disciplined for misappropriating $150,000 of a client's, elderly client's trust account to renovate the elderly client's home, and that attorney went through CSLB and created a construction entity and placed an unlicensed handyman from San Francisco on a license with a retired licensee who lives in Idaho. This is a common thing. You can peruse licensing records and see folks that live hundreds and hundreds of thousands of miles away from each other that are on licenses together. So what this does is CSLB really has no mechanism with which to measure the business equity among the widely varying number of state and national corporations that submit applications, but the business equity provision allows individuals to simply claim on an application that I have this percentage equity in these common entities, and therefore I can qualify an additional license. The problem is our technicians cannot, they process thousands of documents a month, and they cannot verify those claims. It's not clear what business equity means, and we don't have a mechanism to demonstrate proof that the ownership claims are valid. So this would eliminate, not only would it return to consumers some leverage to be able to obtain a bond of a qualifying individual if there's a harm, an additional qualifier bond, it would prevent the ease with which individuals can qualify multiple licenses.
Very good. So before I take comment, staff recommendation is the follow. That the Ledge Committee approve to move to the full board the sponsoring of legislation that requires qualifying individuals to obtain a bond of qualifying individual for each additional license when they act as qualifier on more than one license. The recommendation includes a request that the committee delegate to the registrar the authority to make minor and technical changes to the proposal as necessary. Is there anything from the public? Anything from the board?
So
Yes.
So all this is going to do is basically say everybody has to have a qualifying license, bond for every license.
That's a much simpler way of stating it than me. Just one point of clarification. That is correct. It's not going to involve sole proprietorships, number one. So exclude those and exclude joint ventures. It's going to be for every second and third license qualified will require a qualifier bond. And currently the qualifier bond is at $12,500. So,
Mike, how many people will this impact?
correct.
Oh, qualified.
Yes,
bond,
and
that's right,
I
okay.
neglected to leave out a significant point here. Our research, our initial research, suggests that this would affect about 6,000 licensees out of the 280,000 licenses, active licenses. And so yes, that's it.
Anything else?
I just want that.
Okay. This is yeah. Come on up and tell us what you got, Rick.
Good morning, Rick Piers. So, Rick Piers, Basic Crafts. So, do I understand that you're going to go to, let's say I've had 3 licenses for a long period of time, okay? And you're going to look at them, and the first one, I don't have to have the qualifier bond, but the second and third one I will.
It depends what the entities are. The sole proprietorships, sole owners
Let's
are-
imagine they're all 3 corporations. Let's make it simple, because that's a 20% ownership thing, or partnerships, it doesn't matter. But the first one gets to go free, if you will, and the next 2, you're going to now require a qualifying bond.
Correct, and Kurt will correct me if I'm wrong, but this won't be retroactively applied. It'll be moving forward if it's ultimately accepted, and it will be in the second and third licenses qualified. And then, as you know, 7068.1, you may only qualify 3 within a 1-year period.
Correct. Okay, thank you.
Do you have a concern to note, Mr. Pierce?
Personally, I would think that if you're going to have qualifying bonding, you might want to consider it for any time someone is not the sole proprietorship. Because then you're picking and choosing who has a qualifying bond. So if I do work with ABC and they were the first corporation, then there's only the one bond. But DEF, since they were second, has this additional coverage. So it seems to me there's an inequity on which company, and I might use it as a salesperson saying, well, you don't want to use ABC because they only have one bond and we have 2 bonds. You see where you have a sales kill if you're talking about home improvement, because these licenses are not just commercial licenses or new commercial. They're often residential works. I mean, the reason why we're only allowed 3 licenses, which was not the rule in the 1980s, is because we had a company who was doing plumbing, home improvement or plumbing repair that had 25 different licenses in the state of California. And that's where this rule came down to 3, because there was no way that individual was really controlling the 25 different companies. And kind of the agreement was that there was, someone could control 3. That was the negotiated thing. So to me, it sounds, I think it's a good idea. I just think that you're leaving some space open for number 2 and number 3. I think if a person's a qualifier and not the sole proprietor, maybe there should be a bond irregardless of if it's the number 2 company or number 3 company.
Thank you, Mr. Pierce. Additional questions from the public? Additional questions from the board or committee? I have a question, or maybe a comment. In light of what Mr. Pierce said, when you take legislation to the legislators, and there's a concern like Mr. Pierce just echoed, those bills tend to get killed. So what type of research did we do? Did we talk to industry? And I guess it's not just on this, but some of the other bills. We want to be successful and we want to be forward-looking, not to cast blame on anyone. Have we spoken with any industry? Have we spoken with, what do you guys got?
Go ahead.
Yes, well, we did have a meeting a couple of weeks ago, and we had representatives from the Association of General Contractors, the California Building Industry Association, and the CME. I'm not sure the acronym for that. Mike Curry was there. So we did discuss these bills, specifically that one. I do think Mr. Pierce brought up a very good idea. I don't know if there's an ability to consider his suggestion.
There is. The staff recommendation for this meeting does include the opportunity for the registrar to modify the language, and that's what would be necessary to incorporate Mr. Pierce's concern. Really, the issue is not the idea that you have, which is kind of the intent of this proposal. The issue is the way that this language is written and the fact that there's a definition for a firm in the statute and that is nowhere else in the contractor's license law. It makes it very complex for the authorship of this. So the intent is there, and we will work on the language. It's a very complex issue to draft, and there's multiple statutes involved, but loud and clear on the idea.
Yes.
So, Chair, it feels like it's not quite equitable, you know what I mean? It feels like there's a little bit of an equity issue here. And I'm loath to just move it on without kind of addressing that equity issue.
You're absolutely right. This board can make a motion to follow staff recommendation, or, I'm sorry, this committee can also make a recommendation to send it back to staff and work on it a little bit more and then bring it back to committee, or we can recommend that they work on it, bring it back to the board in December, and then it won't be a fully formed motion, but it will be something that we can discuss at the time.
Well, I'd really support sending it back, whether it, I would prefer it came to the committee, but I know that we have a short time frame, and I don't know whether you can actually address the equity issue because of the complexity. I am concerned about that, and so whatever the chair feels, but I would like to push it back one way or the other.
Would you make that in the form of a motion?
I would.
Is there a second?
Second.
There's a motion and a second, so Clifford, Hancock. There's a motion and a second on the floor. Is there any additional comments from the committee? Any additional comments from the public?
I'm not sure what the motion is.
The motion is to send it back to staff to work on it and then bring it to the big board. Thank you.
Mr. Chairman, if I could, and I guess the staff issue to be addressed would be the equity issue brought up by Mr. Pierce and how that would affect the licensing population.
That is correct. I would encourage staff to work with not just the contractor associations, but everyone who's a stakeholder Mr. Piers, you have one last brief comment? Reader's Digest.
I also think that you need to talk to the bonding companies. I don't think there's an issue with having individual requiring the qualifying bond, but if for some reason they do have it, they have killed similar bills or increases to the bonds in the past. So even though they probably have no problem with it, I think the larger bonding companies would be worth it to have a conversation with them so they are in support of the bill and don't somehow have a knee-jerk reaction and try to have a negative response to the situation, to the bill.
Thank you, sir. Once again, anything from the board or staff?
I wasn't clear as to whether that was the motion to move it to the full board. I mean, I heard kind of
What's
the
your motion?
combined motion from the other end of the table.
You did, so let me relatively soon, right? In other words, it'd be very hard for the staff to both do it and meet a committee and do the board. So if we want it to happen, what I would want to assure is that there was a full discussion at the board. In other words, there was the ability to have, and sometimes that's a difficult. So I'm really looking at the chair saying, you know, how do you feel about moving it to the full board or moving it to the committee?
Here's the issue we have, is that January is
Is
when
our
all bills are
legislative.
born.
Right.
And
I recommend we
yeah.
move it to the full board.
Okay.
And that could be subject to amendment during that full board meeting.
Absolutely.
Absolutely.
Yeah.
But then, as the Ledge Committee, we have the opportunity, not only will additional industry be able to look at this proposed bill or legislation, the Ledge Committee there will also be able to offer their opinions, and the full board and industry and public will have an opportunity, a couple of months, was it next month, about 30 days, to look and see what's going on as well. So the transparency thing works. But that's why we were in a rush to have this meeting, because legislation's in January, and we want to be at the top of the list and not at the bottom.
Right.
So do you agree with that?
Yes.
Okay. So let's go ahead and roll call, please.
Augie Beltran,
Aye.
Linda Clifford,
Aye.
Susan Granzella,
Aye.
Joan Hancock.
Aye.
Thank you, Michael. Motion carries. We move on to item number 3, clarify authority to hold informal citation appeal conferences. There is a handout, number 3. Go ahead, Mike.
So this is another issue of a last-minute change to the language that is printed in the committee packet. Again, the idea has not changed, and the last-minute change is actually going to, it's much better language. So what this does is, for many years, CSLB has informally modified its administrative citations after issuing them to contractors to the benefit of all parties who wish to avoid the time and expense of formal hearings. The authority to do this is implied within the common law, and it is also expressly provided in statute to many DCA boards. So what this will do is make CSLB one of those DCA boards to do something it's already doing. The conferences here are really, it's an opportunity to have the cited person tell the side of the story to a responsible government official, which would be represented by CSLB. And that's not something that can happen in the field when the citation is issued. These informal conferences are not administrative conferences. There's not a discovery process. There's not a review of evidence. There's not a dispute on the merits. Really, it's for the contractor and the CSLB to work out, oftentimes, just a payment schedule. And it does not abrogate the freedom of the licensee or the cited person to formally appeal if they wish. What this does is put in statute the informal settlement conferences that have already been occurring for many years.
Okay, so it sounds like there is a staff recommendation that we approve to the full board the sponsoring of this legislation requiring qualified individuals to obtain a bond of qualifying individual for each, oh, wait a minute, I'm on the wrong page. We went through that circus already. Okay, so They're asking Ledge Committee to move to the full board the sponsoring of legislation that authorizes the registrar to hold informal office conferences relating to citations. The recommendation includes a request that the committee delegate to the registrar the authority to make minor and technical changes to the proposal as necessary. Basically, we're calling people into the principal's office. Anything from the public? The board on my right?
Yes, sorry.
No, it's fine.
So when I read the new handout, right, the language is actually really different than what was in the book. And I think, you know, and I'm not the expert, but I think that it says close to the same thing. But you actually organized it a little bit differently. And, but basically, we're supposed to take this entire section and just overlap this, right? Correct?
That is correct.
Okay. And obviously, you clean this up, and so, do you feel strongly that, when I read it, I think that it says the same thing as this, right? Okay. So,
Define the intent.
Sure, so, thank you, Mr. Chairman and members. So, most of the DCA boards and bureaus rely on a generalized statutory section early in the B&P code for the issuance of citations and the hearings that follow. BAR, auto repair, and CSLB don't do it that way. They have their own statutory mechanism. So what I was, again, this is the last minute, my fault again, Mr. Domesky, Mr. Corker and I met. This was taken from the BAR statutory scheme, which does it like CSLB. So what I've done is taken the BAR informal conference statute and suggested it be revised slightly to fit within CSLB's statutory scheme. The intent is the same, to legislatively authorize and legitimize the holding of the informal conference. So the intent is the same. The words are slightly different. I think this is a little bit better product than was originally presented, so.
So is it fair to say that basically what happens is we kind of come up with what we want to make those changes, and then either you or Christie are refining them and using some examples that are already functionally tested, so that's a good thing for us?
Mostly Christie, but yes.
Right, okay, well, yes, I'm definitely in favor of these informal citation discussions.
Thank you.
I have a question.
Yes.
What are the significant differences?
So I can tell you that the previous language that was published was I believe it was from the Pharmacy Board. And as Kurt said, we replaced it with the BAR, the Bureau of Automotive Repair statute, and really it was a functional difference because their statutory scheme actually simply worked better with CSLB's existing statutes than did pharmacy. So really the only significant changes here are clarity of language for one, but also there was a 15-day, 30-day issue in the previous statute that is now reconciled to better fit with CSLB. Other than that,
I guess that is specifically my concern, is whether the 15 days is a fair amount of time for a reply.
and the reason for that is our existing statutes that provide for administrative hearings for an appeal provide the 15 days. So we can't provide a greater period. We want to line those up to have somebody the opportunity to appeal directly to get their formal APA hearing, or appeal for the office conference within the same time period. And then if the office conference doesn't work out, they're afforded the opportunity to then appeal to the formal APA.
I actually thought that reconciliation was a good thing. We've run into that problem at the QCAC where, you know, the things go too far and then they lose their ability. So this is actually keeps their ability if it doesn't work out. And so I would think that that would be a very positive thing for anybody who is going through the process.
That's absolutely right. And, you know, while we don't have a crystal ball, what we anticipate is this will continue things as they are already occurring. Most folks who simply want an opportunity to say, here's what happened, what is my fine, will not, we don't anticipate they will all be appealing, but the right to do so will still be retained with the new language.
Anything else? Joan?
Well, is there any language if somebody has a legitimate reason for not filing the contested citation notice within the 15 days? Let's say they have a legitimate reason. Their significant other dies. I don't know what that would be, but I mean, is that within the registrar's ability to
Yes,
waive the requirement and allow somebody to file late?
you're talking about the day window.
Yeah.
I believe, and I'm going to look right now, I think it's 7099, which will mirror the 7028 unlicensed statute. It does say that there is, fails to notify, the 15-day period may be extended by the registrar for cause. So that exists.
Thank you.
So we can do it.
Thank you.
Thank you. Anything else from the public? Anything else from the board? So staff is asking us to move this as a fully formed motion to the big board, authorizing the registrar to hold informal office conferences relating to citations. The chair would accept the motion at this time.
So moved.
There's a motion. Hancock. Is there a second?
Second.
Granzella. Roll call, please.
Augie Beltran,
Aye.
Linda Clifford,
Aye.
Susan Granzella,
Aye.
Joan Hancock.
Aye.
Motion carries. Number 4, increase the statute of limitations to prosecute a contractor for failure to secure required workers' compensation coverage.
Where's number 4?
Page 10.
Yes, that one's in your book.
What page?
Sorry, my page 10.
So what this does is the contractor state license law has within its Article 7 workers' compensation provisions a single statute that says that a violation by a licensee of those sections shall be a misdemeanor. And then if we fast forward to the penal code, that penal code specifically provides that section from the contractor's law 2 years in which to prosecute those actions. And then if we move over to the labor code, where it's a violation of workers' compensation laws to not provide coverage, those are all 1 year. So what this will do is simply reconcile those two statutes. The issue here is primarily our reactive cases. So as many folks know, our proactive cases where we have boots on the ground folks that open up complaints for violations in front of them, those are not an issue with the statute of limitations. What the issue is the reactive cases filed by consumers. Oftentimes the consumer or a homeowner will not file their complaint with CSLB until a couple months after a job, 8 months, a year after a job. When that occurs, we effectively lose the ability to prosecute any of the 1 year statutes of limitations for basically unlicensed contractors. So this would allow consumers who file their complaints sometime after the work at issue, we would be able to refer a significant number of workers' compensation cases to prosecutors if this proposal goes through.
Yes, Registrar.
Just to clarify, we currently have 2 years for a licensed contractor, but this would just bring into alignment the investigations against unlicensed contractors. We have 2 years for a consumer to file against an unlicensed contractor and refer that case to the district attorney.
Correct.
Anything additional from staff? No. Anything from the public? On the board, on my left.
I do have a comment.
On my right.
Did I surprise you?
I'm just playing.
You're right. We talked about this earlier, Mike, but just wanted to say that when we do bring it up to the board, a clarity of the change control and a separation of what the issue is at the beginning so that we can move into a discussion about the detail faster. But you've done a great job. I know this is your first meeting, but I wanted to say thank you. And we look forward to that at the board meeting in December.
Very well. Good job.
Thanks.
Staff would like the Ledge Committee to move to the full board a fully formed motion sponsoring legislation to increase the statute of limitations during which to prosecute a contractor for failure to secure required workers' compensation coverage. The recommendation includes a request that the committee delegate to the registrar the authority to make minor and technical changes to the proposal as necessary. The chair would now accept a motion.
So moved.
There's a motion on Hancock, and the chair will accept a second.
Second.
There's a second on Granzilla. And you may call roll call. Oh, hold on the question.
Thank you on the question. So basically what the staff is saying is to increase, but I think it's actually to reconcile the labor code with our code so that we both have 2 years.
Is that correct, Counselor?
I believe that is correct.
Thank you.
So I'd feel better if we said that's what we're pushing forward.
Do we need to amend the motion to use the word reconcile?
I think it's inherent, Mr. Chairman, that we can just, we're amending this with the purpose of reconciling those two.
Okay, motion stands. Roll call.
Augie Beltran.
Aye.
Linda Clifford.
Aye.
Susan Granzella.
Aye.
Joan Hancock.
Well, darn. We're up to F, strategic plan. What you got, Mike?
At the very, very end of our enormous packet on page 249, we have the Legislative Committee Strategic Plan updates. As we know, my mentor here, Laura, was wearing 2 hats last year, and for both the Licensing Committee and the Legislative Committee. We would like to change some of the dates for the strategic plan as follows. The strategic plan, staff recommends revising the target dates as follows. So now we're on page 251. On item 3.1, from May of 2017 to June of 2018. On item 3.2, from May of 2017 to February of 2018. And on item 3.3, from June of 2017 to February of 2018.
Thank you. Any comments from the committee, starting on my left?
I'm in support of that.
On my right?
I do just. Yeah, right, I know. Well, especially because Laura and I have been talking about the draft contract license law for, quite some time. Are we, and I don't think June 18 is there's nothing wrong with these targets. I'm actually very good. I would just like to have a little bit of an update. How far are we into this? Are we, is this really, we substantively have begun it and it's really just, taking longer? It had to, because there was so much to be cleaned up.
Yeah, I completed a draft over a year ago. So there's a complete draft of rewrite and reorganization of the law, and it's really more, it's technical. It's a reorganization and clarifying changes, not, substantive changes. So it is complete. It's really just now Mike and David are going to need to review it to see if they're comfortable with it. It was
Okay.
something I worked on with Cindy.
Right, so this is really the review process. We have a product and you guys are just, and it's a lot to look at, I know that. So we're really we're on the downward.
Right, it's not starting at the beginning.
Yeah, okay, all right, thank you.
Anybody in the public wish to say something? No. Chair would accept a motion at this time.
So moved.
Second.
Clifford Hancock? Thanks. All right. Roll call vote?
Augie Beltran.
Aye.
Linda Clifford.
Aye.
Susan Granzella.
Aye.
Joan Hancock.
Aye.
Well, we now reach the time that we all look forward to, and some of us don't look forward to. I'd like to stay here another few hours and talk, but
I heard you were buying breakfast for all.
I think we're close to
Only if we
lunch.
got done before 10.
Oh, so we got another 20 minutes here. Okay, so motion G, adjournment. Is there a motion to adjourn?
So moved.
Aye, second. I think I should second.
We have a motion and a second. Roll call, please.
Augie Beltran.
No.
I've been waiting for that to happen.
Linda Clifford.
Aye.
Susan Granzella.
Aye.
Joan Hancock.
Aye.
You could change mine too.
I'll change Augie's to an aye.
It's peer pressure, right? Thank you all. We will see you next time in December.